The following is the Honorable Washington Windsor's Post. NPEs are entities that do not make products and don't offer services, and are often called patent trolls that employ patents primarily to obtain license fees rather than to use technology they own to make products. 5G IP Holdings LLC is a NPE and one of the famous patent trolls, amassing a large number of patents with the intent of filing patent infringement suits against companies and individuals they believe have illegally used some element of something for which they have a patent. 5G IP Holdings bought the patents from Taiwanese FG Innovation Company. Months later, 5G IP filed a patent infringement suit against Samsung on August 6, 2021. NPEs aim to generate profit through patent infringement lawsuits and mostly target big-name players such as Apple, Amazon, Samsung, and LG Electronics in the U.S. market. 5G IP Holdings LLC is represented by Adam Akhtar Allgood, Alan Michael Fish, and Ken K. Fung of Fish Singler, LLP. The plaintiff filed the complaint for alleged infringement of the 150 patent U.S. patent number 10,624,150, entitled Radio Resource Control Connection Resume Method of Wireless Communication System, the 163 patent U.S. patent number 10,813,163, entitled Devices and Methods for Controlling Discontinuous Reception in New Radio, and the 649 patent U.S. patent number 10,868,649, entitled Method for Signaling Bandwidth Part Indicators and Radio Communication Equipment using the same, according to the Texas Eastern District Court records. Nature of the lawsuit: willful infringement. The plaintiff asserted in the complaint that defendant Samsung has infringed and is infringing, either literally or under the doctrine of equivalence. 5G IP also asserted that FGI clearly and unequivocally declared the 150 patent to be a mandatory requirement for the 5G standard. Thus, the plaintiff claimed that Samsung should have known of the 150 patent and of its infringement. The nature of the lawsuit is a willful infringement. The plaintiff claimed direct infringement, such as selling, using, offering for sale, importing in the U.S. without authority license, and indirect infringement inducing Samsung customers, retailers, end users, and resellers by knowingly and intentionally. IP or declaratory judgment. I applied IR and declaratory judgment concepts that we learned from Module 6 to this case 421 CV00622. The case is currently closed because two parties made a settlement during the pending IR case before Tab. USPTO. Samsung had two choices to defend the patent infringement. One is a declaratory of judgment seeking only a judgment of non-infringement, and the other one is filing a or challenging validity of claim. Samsung decided to challenge the validity of the claim through a proceeding before the tab of the USPTO. Board assigned the Hun Philip Kaufman, Michael Seigan, and Scott Daniels as administrative patent judges for these IPR cases: IPR 2022-00553, IPR 2022-00559, and IPR 2022-00563. Board granted joint motion to terminate proceedings due to settlement before institution, and granted joint request to treat agreement as business confidential information. Based on the decision by board, there is no way to find out how much Samsung paid to 5G IP Holdings LLC. But I think that Samsung paid a lot of money for 5G IP. Jurisdiction: many NPEs opened the business in Texas because, as we learned from the Hun Prof Caps, the Federal District Court of Texas has maintained a high reputation of pro-patent owners and infringers. Caps. 2022. The Federal Trial Court case of Texas terminated automatically since two parties made a settlement during IPR proceeding. 5G IP issued a license for Samsung since Samsung agrees to pay compensation awards and costs for a license. As an American, I think that NPEs are doing good jobs to protect national interest, inventors and scientists.